I think my initial reaction shortly after the decision is that this is a slightly good thing. And the reason I say that is you've kind of taken an iron fist out of an agency's hands with this decision.
Landline now, welcome back. Late last month, the Supreme Court overturned something called the Chevron doctrine, stripping some of the power that federal agencies have to make and enforce regulations. In the hours after the announcement, we spoke with Paul Torlina, OOIDA Government Affairs Counsel, for a snap reaction. But the decision is so rife with potential consequences and still producing so many questions, we thought it might be a good idea to have Paul back on. So that's what we're doing today. Paul, good to see you.
Always glad to be here.
So for a quick refresher here, the decision, as we talked about before, makes it harder for federal agencies to wield power not specifically provided to them by Congress. Is that a pretty good summary?
Yeah, I think it is.
Okay. And for a quick note here, too, we've been calling it the Chevron doctrine, which is not wrong, but there's kind of a new name that people are going to start hearing with regard to this, right?
Right. The case that we're going to be talking about is called the Loper-Bright case. It is the case that the Supreme Court decided, as you said at the end of last month, that overturned the Chevron doctrine. So for purposes of our discussion, I'm going to say Loper-Bright just because I think that's how it's going to go in the future.
We're going to slip up, though.
We're probably going to say Chevron every once in a while. And for those listening, we're talking about the same thing when we do that.
Very good. So as we talked about before here, the implications of this are wide-ranging. I want to throw a hypothetical at you here in just a moment, but I do want to kind of do a rapid-fire back and forth if we can, because I know OOIDA in particular has been getting a lot of questions about this. Mm-hmm. Again, this is a confusing situation. Anytime you deal with courts and all this, it's going to be confusing. But a lot of questions are out there. And if you're game, we'll do that here real quick.
Absolutely.
So first question we've been getting is, does this ruling by the Supreme Court mean that all the moves made by FMCSA and EPA and other agencies in the past are all of a sudden going to be overturned?
No, it specifically does not mean that. Now, it does mean that they are up to be challenged under a different standard or roadmap, whatever you want to call it, but nothing automatic has happened as a result of this Loper-Bright decision.
I know there were some people out there who maybe got a little excited or hopeful that this would mean that things like the ELD mandate were going away. That is not the case. It is here to stay.
Correct.
Just in the context of this discussion, right?
Yes.
Okay, so that's staying. Other things that we've seen are staying as well. However, we should mention that rules mandated by Congress could still be challenged, right, in courts of law across the United States.
Rules made by Congress are challenged all the time for constitutional reasons, but that is not a Loper-Bright or Chevron analysis or discussion. That is something more like the Commerce Clause or the Due Process Clause or more technical parts of the actual U.S. Constitution.
And those are things we see play out all the time. Those will continue playing out the way we've seen them.
I'm certain they will, yes.
Moving forward.
Yep.
Okay, so we've kind of looked to the past here. Again, pretty clear that past decisions, past moves, regulations, whatever you want to call them, are going to remain. The questions become a little more layered when we look to the future and decisions that are currently being made. A prime example of this, I think, is a speed limiter mandate. Tons of discussion about this. Obviously, FMCSA wants to move forward. That movement has been a bit slow of late, but as we put that into this context of this Loper-Bright decision, something like a speed limiter mandate, what does that mean with regard to this decision?
So just to back up a bit, we talked real quickly about ELDs, and the reason that ELDs are not open to challenge here is because Congress very specifically mandated a rule for that. They asked FMCSA to put a rule together implementing ELDs. That's why it's not able to be challenged under Loper-Bright, because Congress specifically directed it. Okay, now on to speed limiters. If FMCSA were to make a rule mandating speed limiters or implementing them, they would not be doing so with direct language mandated by Congress telling them to do so. As of right now, there is no statute out there that Congress has created to directly mandate FMCSA to create speed limiters or rules about speed limiters or implementing speed limiters in any way. So what would follow is FMCSA would be acting on their own and assuming that they have that authority from Congress, then making a rule. That is prime Loper-Bright grounds for a challenge. So what we would have there is Loper-Bright analysis now says, did you have the power from Congress? The answer is probably no.
Mm-hmm.
Or did you think that you had the power from Congress, and so you made this rule? Is the rule reasonable or permissible under, I guess, logic, I guess is the best way to say it. It's hard to explain permissible, but under some analysis showing how they came to it, using their expertise, how did they implement research and data and things like that. But again, that's fertile grounds for a challenge under the Loper-Bright case now. And what's going to happen in that situation with speed limiters, if they were to be mandated by FMCSA without a mandate from Congress, the analysis now that Loper-Bright has overturned the Chevron doctrine, is to say we no longer have to automatically defer. And when I say we, I mean the court does not have to automatically defer to the FMCSA anymore. The court can make its own decision using all factors in play, all facts and circumstances, all evidence, such as they did back in the 60s with, or I guess it might have been the 50s, I don't remember the date exactly, with the Brown versus Board of Education case, which we were on before and I misspoke about that and called that Marbury versus Madison. But when they did the separate but equal analysis under constitutional law back then in Brown versus Board of Education, they did exactly the same thing. So in these situations now under Loper-Bright, the court would do exactly the same thing that they would have done way back then in Brown versus Board of Education or any other case that they hear. They no longer have to say, oh, well, we're required to automatically defer to FMCSA because they made this rule and it appears to be reasonable.
What I'm hearing here is that, let's say FMCSA tomorrow or next week or whenever it is down the line here decides that they're going to move forward with a speed limiter mandate. This decision makes that road much more difficult for the agency to do that.
It does. They're going to have to cross their T's and dot their I's more carefully to make sure that their action is one that they were empowered to take and one that they reasonably took that was permissible in the event they did have the power to take it. They're going to have to be more careful.
I mean, as of right now, looking at the language, it doesn't appear that they would have that power. Again, just talking speed limiters.
Agree. As we said earlier, there is no mandate from Congress right now specifically telling them to create a rule implementing speed limiters.
So again, this creates a lot of turmoil, and I think we've kind of cleared it up pretty well here. And we don't have the answers here. We're going to have to wait and see how a lot of this plays out, obviously. The last time we spoke, and we've talked about this before as well, but you were kind of digesting the decision and what it meant. It had just happened, obviously. You've had a little bit of time now to let this all marinate, to kind of think this over. I think the jury is probably still out on whether this is good, bad, neutral, whatever. Your thoughts, though, obviously, as you've had time to think about it.
Well, I agree with you that the jury's still out, and it will be for a while. This is going to be a long-term thing to figure out exactly whether it's good, bad, or ugly, or indifferent. But I think my initial reaction shortly after the decision is that this is a slightly good thing. And the reason I say that is you've kind of taken an iron fist out of an agency's hands with this decision. Loper-Bright now puts the power in the hands of the courts to decide this rather than to just automatically defer to an agency. And the reason I say that is good is that it just puts more checks and balances in place for a court to consider all the facts and circumstances. A judge would have to follow case law precedent when making these decisions, if it exists and is on point, of course. But that's much different than the risk that you're just hoping that the agency gets it right when they make their decision. Now, there's a flip side to that certainly judges could be motivated by their own politics or views.
Sure.
An agency most certainly is going to be a politically motivated agency under the regime it operates under on whoever's in office. So that's also there. But I think that balance tips in favor of it being good when you have the judges who are subject to some checks and balances.
Complicated but important matter. Paul, thanks for your time and your expertise. We appreciate it.
You bet.
And that's our show for today. We thank you for tuning in wherever you may be, and wherever that is, drive safe and take care.